Hi, in this presentation I'm going to try to show you how important concepts in law can be misunderstood, but also interpreted differently based on how people see the world and what their worldview is. And I'm going to do this by looking at the Chisholm case that you read and looking at the three different legal opinions and try to compare that to how you generally think about the concepts and see what you kind of do in response to some questions that I ask you. So what I asked you to do was to read the case excerpts and then, or the full cases for those of you who don't have the book, and to pull out some kind of language from there that helps you identify which of the three justices you agree with more. So I just wanted to pull out my interpretation of what they're saying. So with Justice Iredell, sovereignty in his idea is divided, and it's divided through the text of the Constitution, where it explicitly says what Congress is supposed to do, what the president is supposed to do, what the states are supposed to do, what the courts are supposed to do, and also through legislative text. So when a state or Congress passes a law, then you can look at that text as well, and it should say specifically what you should be able to do. So in that sense, without explicit constitutional or legislative text, then you retain, or individual states retain, whatever is not mentioned in the congressional text or in the constitutional text. So in other words, if Congress or the Constitution is going to take the decision making away from the states, it has to do so explicitly. It has to say this is what it's doing, and presumably it'd have to say why it's doing that. So in other words, the states are sovereign unless or until the Constitution or Congress says otherwise, provided they're following the rules of constitutional principles. So this will become clearer. I don't think it. In some ways, it makes sense once you think about it a long time, and you've been doing this work for as long as I do. But if you were just to read this right off the bat, I'm not sure it would make a whole lot of sense. It's just this idea that it's being shared through some kind of document. Whereas Justice Wilson, in his interpretation, sovereignty as a concept is replaced altogether by three other concepts. So his concepts of rules, rights, and obligations are kind of what lead up to sovereignty. So how do I know someone's free, or how do I know who the decision maker is? Well, I'm going to look at the rules, the rights, and obligations, and then I'll know. So to the extent that one is embedded in these social systems of rules, rights, and obligations, so you are free. So the more you as a human are involved in or engaging with these processes of rulemaking, of passing rights, and of thinking about what rights are, and then holding up your obligations, then you more or less are sovereign or free. Justice Jay, on the other hand, uses this metaphor of housing. So we're all joint tenants as citizens in this property of sovereignty. So we're all kind of living in sovereignty, and that being those who are actually governing. So the people who are governing are the ones who are sovereign. It's very unclear who the other people are. So I kind of think about it this way as landlords and tenants. So in his mind, the sovereigns are the landlords who actually own the property, and they're sharing in the owning of the property, where the rest of us would be tenants. So we still have some sovereignty, we have some freedom, but we're at the kind of mercy of the landlord. Okay, so if we take those three different interpretations, who or what then is sovereign? So you've got really one way of thinking about it where it's in sovereignty. So those are the dominant social groups. So that's the idea that we're all living in a house together. And so who's sovereign? Well, the ones who are taking charge, right? The ones who are actually doing the legislating, the ones who are in the courts, the ones who are, effectively making the policies for all of us to live by. On the other hand, we've got this idea of with sovereignty, and this would be more of the dominant social norms and the processes. So this goes back to that idea of the rights, the rules, and the obligations. And so you kind of know, how do you know who's sovereign? Well, who's running, who has the most rights, who's able to exercise their rights, are they fulfilling their obligations? and are they following the rules, right? That would show you who's sovereign, or probably even more likely who's enforcing the rules, right? And then you've got this third idea from Iredell, which was this 3 levels of process. It's the highest is the Constitution, the next highest is the Congress, then the next is states, as long as we're talking about words that each has passed. And so you've kind of got this before sovereignty, as if I'm before the Constitution, I'm making an argument to the Constitution, or the lawyers interpreting the Constitution, or I'm before the Congress, I'm at their mercy, I'm trying to plead my case to them and say, this is what I'd like you to grant me, you're the sovereign, now give me my rights. On the other hand, if you're a state, you feel like you're up against the sovereignty in this system, right? You're trying to take power and keep it, right? Instead of having it go away to the Constitution or the Supreme Court or to Congress, you're trying to hold it yourself, so you feel like you're up against this sovereign power. So we've got in sovereignty, with sovereignty, before sovereignty, and up against sovereignty when we break down what these 3 gentlemen actually meant. So let's say we then want to apply this model to a case, which is the next case in the reader, which is the Korematsu case, in which an individual, a citizen, was detained in a detention camp along with other Asian Americans because of his national origin. So if we go over and we say, okay, if it's the dominant social group model and that's how you're thinking about sovereignty, then white European Americans took more sovereignty than Asian Americans, meaning white European Americans were not jailed, they were not detained because of their ancestry, they were the ones they were dominating another group. And so that kind of sovereignty shows us the inequality of sovereignty, that dominant social groups can take more of it when they choose to do it, and they can take away sovereignty from other people. If we think more about the rules, the rights, and the obligations, then we think about, well, but it's still dominant social norms, right? Because they're the processes of white European Americans, and those were not given to Asian Americans. They didn't have the right to trial. They didn't have a right to habeas corpus. They didn't have a right to liberty, right? So none of those social norms actually applied to these groups of people. Those were taken away by the dominant group. So the dominant social group and the dominant social norms and processes kind of blur together here now. And so now we've got this problem of it could be with sovereignty, of course, unless you're the people who are getting your sovereignty taken away. And so now you're without sovereignty. So we say, okay, hopefully maybe Judge Iredell can help us with this. We look back at his formula. So in the Constitution, the 14th Amendment, right, which is supposed to be supreme, says you cannot take away people's liberty based on national origin. The Congress, however, had passed a law saying that, well, yes, you can. And then the states are excluded from this conversation. So again, you see they're up against sovereignty because there's not really much the states can do to stop the federal government and the military here from detaining these citizens. And you could argue it's before sovereignty because Congress authorized this unconstitutional behavior. But so how come the Constitution doesn't win out here? Why is the Constitution not sovereign? Well, we go back to this formula and we say, well, if the dominant social groups and the dominant social norms and the processes are sovereign, then it's going to be their interpretation of the Constitution, and in this case, they just want to ignore it altogether, and they want to ignore the states, and so that's what happens. So sovereignty, then, when you apply it, you can see that it's given or it's taken as a tool with they've got the sovereignty and they're taking it from people who are without sovereignty. So if I now look at the student answers that I've gotten over the years, you'll see that the overwhelming number of students are looking at that kind of nice process that Judge Iredell is kind of throwing out there, that, oh, wouldn't it be nice if the Constitution was sovereign? And then the Congress did what they're supposed to do, and then the states, if all 3 of them work together, then sovereignty would be shared in this kind of nice house, right? The idea, of course, then, I think that's maybe a lot of you are saying you'd like it to be this. You'd like sovereignty to be a compact between citizen states and states with their government. But I want you just to think about, if that were true, if that were happening, we'd constantly be in conversation. That's not a bad thing. We're going to get to a question later of, are you willing to do that? So you'd be kind of having to participate in the political process every day, right? It wouldn't be just something you get to have an opinion and talk, without any information or research on social media, right? It would be something where you actually have to get involved, you have to learn, you have to participate. And so that's really what that Constitution, Congress, state formula would look like. Other of you looked more at the dominant social norms and processes than dominant social groups, right? So you're seeing that as, well, let's let the state representatives do it, or let's just kind of stick with this idea we have of the people, which is where, people vote, they pay their taxes, and that's kind of good enough, right? And so we're kind of giving our power, we're giving our sovereignty away to the people we vote for and the people who collect our taxes. And to other agencies like the police and healthcare and all these other things where we're giving our sovereignty, our decision-making power to other groups of people. And then you'll notice, interesting, right, that 16% of the students have introduced this other idea, which comes from natural law, of which the Constitution is based on, of which, well, hold on, maybe the individual should be sovereign. Maybe you shouldn't give your sovereignty away to these other groups. I do want you just to pause for a second and just let it sink in that, so students don't have the same idea, right? So you all read the same thing, and yet you come to 4 different conclusions as to what you agree with that sovereignty should mean. So just to keep that in mind, right? So we started with a case in which 3 judges disagree. Now we've got up to, as many as 30 or so, well, 35, 37 students who are looking at Constitution, Congress, states, and then the rest are looking at these other groups, right? So it is kind of interesting once you just start thinking, okay, wow, this thing I thought was simple according to a Google search where it says, the supreme law of the land or whatever, is obviously not real, right? So the computer thinks it's one thing, and then humans obviously think it's something else. So I want to kind of put this in visual format then to show the 3 different choices, and then we'll come back to the individual later. But so if we think about the Constitution, Congress, states, this must be what you mean, because this is what that is. This is what this looks like. It starts with, if you start at the bottom and work your way up, right, you've got political parties and you've got interest groups. There was just an election in New York, right, and so various people have now been elected, and in theory they're going to do what you want them to do, but of course, what does that mean? How many people actually tell their legislators what they want them to do? Are the legislators guessing? Are they in it for themselves? All these questions are out there that maybe you didn't think about when you said, yeah, I like the idea of Constitution, Congress, and states being sovereignty. The other thing that you might not have learned yet is that political parties are somewhat important, and voting is somewhat important, but interest groups have far more influence over that process and over that view of sovereignty. So interest groups are these organizations that spend a lot of money donating to political campaigns, and then also writing legislation. So they write the laws. For example, Dobbs versus the most recent reproductive rights case, Dobbs versus Jackson. You think about the organizations that were involved in writing the arguments for that Supreme Court brief, and you'll start to see how interest groups have so much power and influence over this Constitution, Congress, state system that people think about. But again, like if you just put it in very simple terms, like this person did on a piece of paper here, it's like, okay, quote unquote, we the people are way down at the bottom, and then you vote for representatives, and then they vote, and then up the chain. And so this idea of Constitution, Congress, and states is really not this bottom layer, but it's actually this top layer of just the select people within the republic who are actually deciding what this balance between Constitution, Congress, and states is. So that's what you're really actually arguing for when you say this is the kind of sovereignty that you believe in. This is what it looks like in real life, and what you'll see is the red and blue thing where it's divided. And so when you're thinking of sovereignty in this term, it's always been divided, largely because the red states are the ones that held the slaves, and the blue states are the ones that were against slavery. And today it's not quite the same thing, but it's not that far off either, where we're still in this embodiment of who gets to decide what this balance is in Constitution, Congress, and states. And you'll see that it's a very unclear view of sovereignty. On the other hand, if you're the kind of person who says, well, I'm more interested in the social norms, and the processes of rules, rights, and obligations, then you'll see it here. And I might go the opposite way this time and start at the top, where the rules are operated and managed by the police. And so there's the rules being forced through dominant processes, and then there's the people resisting those rules. And so in theory, then the norms and the processes are supposed to send this conflict into the courts. You're supposed to have a jury of your peers, and the peers will say, well, we think the police were wrong, or we think the individual protester in this case was wrong. And so your rights will become clear as the courts decide what your rights are in relation to the dominant social norms. And then why do we all think this is great? Well, because you vote and you pay your taxes. And so the dominant social norms and processes are a reflection of what the good citizens believe the difference between domination and resistance should be as we decide in a court of law. This one's interesting, but as we kind of saw in the Korematsu case, and you'll see in other cases, it rarely happens, if it has ever happened. I think it's much better for TV, where you'll see this process happen. But in real life, most cases don't go to trial, so this kind of tension between control and resistance is not ever actually resolved through the legal system. One could argue it's resolved through the political system over here to the left, your Constitution Congress states. So you could say that in the red states they don't like protesters, and maybe in the blue states they're less likely to side on the side of police. I don't know that that's true. That's just the political argument. I haven't seen any good legal or statistical research on that. But you could make that argument that the dominant social norms and processes could feed into this other system. I don't really buy it, but it is possible. So then kind of the more, I think, obvious one is in these three pictures to the right, where I think it's easy to start to say that, well, sovereignty is obviously exercised most often through dominant social groups. So those who decide what you're supposed to consider cool, or something you're supposed to aspire to, or what is supposed to be quote-unquote culture in the United States. Those who are rich, right, get to determine the life chances and where people live and where they work, right? So the poor really don't have much sovereignty. If you're an artist who doesn't agree that these artists at the top are good, or are what should be considered the authority on culture in the United States, then you don't have much sovereignty, right? And then at the worst case, you'll see a dominant social group actually just literally tramping over minority groups to very clearly show that they have sovereignty and they're willing to exercise it. So I think if you were thinking just from reality standpoint, the dominant social group seems to be the one we see every day, that they're the sovereigns, they're the one making the decisions. I think we'd like to believe in these two to the left, and to some extent they are real, but they clearly don't have as much of an impact against this one on the right. As we start thinking about that, this is also what James Madison and others were thinking about it, is that, again, in theory, these two to the left are really supposed to try to limit the influence of this one on the right. And we'll just have to question whether that's actually happened. It doesn't seem to have, but again, we want to spend some time thinking about it. So then I also want to just complicate this other idea of, a lot of you kind of love this idea of we the people, and that means everybody. But when I give you an opportunity to exclude people, you'll see that some people, 33 people, are consistent, and they say no one should be excluded, which is a very modern view of Constitution or of the legal system. Whereas most of you are like most of the people in power. You are interested in eliminating and excluding people right away, which is then kind of say, well, how did Korematsu get his rights taken away? Well, here you are showing how it happens. It just takes a question. Who should I not give rights to? And you are willing, just like all humans, say, well, we have opinions about that. We don't think these people should get rights, etc. Right? You'll even see that some people are so against the other political party that they are willing to take away those rights from those people. That's not uncommon. So if we go back to those three judges, I just pulled out some quotes that kind of help you better understand what they meant. So from Justice Jay's opinion, only those who own the country, so only the wealthy, should be able to participate. And so that's who he meant by the people. The people were the wealthy. For Justice Wilson, has a much more radical idea. No one has a right to any authority over another without his consent. So in his mind, if you're giving your sovereignty away to the Congress, to the Constitution, to your state, to the police, to your teacher, whoever, you must have consented to do that. That must have been your choice to do that. And so you shouldn't have sovereignty if you're willing to give it up so easily, which is, 90% of you are willing to give up your sovereignty just without really much thought. So he assumed that you must consent, that you don't believe that you're capable of being a decision maker. And Iredell kind of puts this even further by saying, do you think the minority would choose themselves to put themselves in a position of power? In other words, he's kind of almost daring people to take on the government if they do abuse their power, similar to the concepts of the revolution, right? That this was the idea. The revolution was all about standing up to groups of people who were taking power or sovereignty over others that they didn't think they should, and so they stood up to them. And so he's just kind of like playing this thought game of if you believe that sovereignty lies with the individual or with a minority group, just ask yourself, are those individuals actually trying to take sovereignty? Are they trying to take power? And that might be a good way of thinking about who's excluded and who's included. So now what's really fascinating to me as a professor, and a couple of students actually pointed out when they were talking about it in their long answers, is once I ask you what's your sovereignty and related to the college classes, it's not surprising to me that most of you pick the dominant social norms and processes, meaning because you've never actually had the chance to grade yourself, or you've never been at a college where there are no grades, which they do exist, mostly among wealthy elite folks, who would sue if they got a B or lower, and their teachers don't want to deal with that. So you kind of just said, well, I'm gonna give my sovereignty the process that I'm most comfortable with, the thing that I know the most, right? And that's for the professor to determine the final grade. Even though you are obviously in a much better position to know what you did learn and what you didn't learn, you see how you just give your sovereignty away to me. You've made me the king. I'm now in charge. And I get to pretty much arbitrarily decide what your grade is. I don't do that, but I could. Almost no processes exist that challenge me, which then go to the dominant norms and processes where we just assume that the professor should be the decision maker, really based on no research or information whatsoever. Some of you are more progressive, you're more modern, and you thought dominant social groups, right? You could form your own student government, you could form your own mini groups inside the class, and you could determine your grades. That would be very much that kind of compact argument that some of you seem to like to agree, but then most of you abandoned it here, but about 25% of you held on to it. You said, well, I like the idea of participating in some kind of a compact. Here would be between the professor, the student groups, and the individual, just like it would be the Constitution, the Congress, and the states. And we'd probably want to refer to some kind of book or decision-making guide in order to make those decisions. But I just want to show you here where you've kind of switched suddenly and you've given all of your sovereignty away simply based on your habits and your experiences, not really thinking about it much. So then again, you kind of flip this again, where now suddenly we've jumped up from 9 to 32% of individuals believing, however, that they're completely free. Again, like in your mind, you might believe that, but then when we go to practical real life examples, you give your sovereignty away instantly. And so I want us to constantly be thinking about that division among government actors, including politicians, justices, police, right? These people who are able to exercise sovereignty every day arbitrarily without any explicit mention in the Constitution, and without any explicit agreement or consent on your part, and contrast that to this idea of you want to be free, or you believe the individual is free, or sometimes you think that the people, quote unquote, are free. And then in between that are all these social groups of which you're a part that are kind of competing towards this kind of domination or towards this resistance. And so when we apply that kind of complication to it, where it's not one thing, but it's all of these things, you'll see in Korematsu, the individual is not sovereign. Congress, the president, the Department of Defense, and the military leaders are sovereign, according to the Supreme Court in that case, but also according to what they actually did, right? They worked together to take sovereignty away from Korematsu and others. The same thing happens again in Johnson, where the individual is not sovereign, not the person who thinks that he bought land, and not the tribe, right? The social group that sold the land, they're not sovereign. The Congress and the current property holder is sovereign. So this one's complicated, I think, because first of all, it kind of baffles, I think, any mind to suggest the tribes were not sovereign when they were told they were sovereign. But then the Supreme Court says, no, that's not what we meant. You're not sovereign in this particular situation. We're going to take that sovereignty away from you. The individual who thought that they were sovereign under property rights was told, no, you're not sovereign either. We're going to take that property away from you. We're going to actually give it to this other property person because Congress said we could. And so therefore Congress and that property holder are now sovereign. So again, you see this kind of very complicated application of sovereignty. And then finally, in the case Hawaii versus Trump, you'll see the state is not sovereign, right? Two states say we don't want to do this. They're not all allowed to do it. Neither are the individuals who are barred from entry. So this idea that the people are sovereign is clearly not the case. And then here we've got Congress, the president, the Department of Defense, and state are the sovereign actors. And so I want you to start thinking about sovereignty as a concept of which applies in particular cases. And so what you'll find is justices of the court, right, judges just like you, will mean different things when they use words like sovereignty, freedom, control, resistance. All of these things are going to mean very particular things. And all of those things exist in our language and our day-to-day realities. And so we have to try to capture all of them. There's not going to be one answer. There's going to be multiple answers. And so we can also see how these concepts are applied by looking at cases, and especially over time, right? So there's a assumption a lot of students, and I think just Americans in general have, is that things get better over time. But when we look at cases over time, we find that's not actually true. And so we want to start making sure we're doing that so we can better understand the concepts, but understand how the constitutional legal system works. And so the two big terms that you're learning here, are new vocabulary, are polyvocality of legality narratives and malleability of law. Polyvocality probably sounds enormous, but it's actually simple, right? It's many voices. Legality is just how we think about law, and narratives are just stories. So many voices or stories about law. And so we've got some that we identified here. We've got before the law, where you feel like you're kind of almost underneath it and you're looking up at it and saying, here I am before you. There's with the law, so that way of thinking is more of like using it like a tool to get your way, like a game. And then there's up against the law, where it feels like, this legal entity or this process is going up against you, and so you have to defend yourself against it and resist it. There's in the law, that kind of metaphor where we're sharing things within it, and so it'll kind of depend on who's sharing more and who's sharing less. And then a lot of you have brought up one I want to include of above the law, and some people can claim they're above the law and then they find out the hard way they're not, but others do kind of operate as if they are above the law, right? So they might not literally, but they're kind of living day to day as if they are, and the courts and the police seem to think they are. And then that shows us then malleability of law, meaning that it's malleable, it can be moved around, it can be reshaped. And so you want to start thinking about it as flexible. It's not one thing, it's not one moral code. It's going to be specific to the case or the controversy at hand. And then principles that come out of those specific cases are going to kind of float there, kind of think about them as just like floating in the air. And then a lawyer and a judge will take this one and they'll take that one, they'll kind of mix it together and attach it to the legal arguments they're making. We call this stare decisis in the common law of kind of adhering to precedents or disagreeing with them through time. And so you want to just kind of now see how this applies to the concept of sovereignty, that's kind of floating out there in different ways, and different narratives, different stories about law will kind of come into different cases. And so you want to start thinking about that in other topics like jurisdiction, due process, privacy, right? There'll be other, the unwarranted search and seizure, right? There, in each of these kind of big concepts, you want to remember there's multiple ways of looking at that particular concept, not one answer.